Welcome to this explainer. Look, Sri Lankan employment law can often feel like an absolute maze of statutes, tribunals, and dense legal jargon. But today, we're cutting through all that. We are going to transform that complex web into a clear, visual survival guide for both employers and employees.
So let's dive right into the highest stakes scenario in the workplace. What actually happens when an employer drops those two dreaded words, "you're fired," in Sri Lanka? I mean, does the employer have the absolute right to just let someone go on the spot? Or does the employee have immediate legal shields they can raise? Let's find out.
Here's our roadmap for today. We'll cover lawful versus unlawful termination, navigating the labor tribunal, a landmark tribunal case, how compensation is awarded, and finally, understanding gratuity payments.
Kicking things off with Section 1, Lawful versus Unlawful Termination.
Right off the bat, there is a night and day difference between a legally justified termination and an unlawful dismissal under TIWA, that's the Termination of Employment of Workmen Act, and the Industrial Disputes Act. Listen, an employer absolutely cannot just arbitrarily toss someone out. On the left, you'll see the valid grounds. We're talking serious misconduct like theft or fraud, or things like genuine poor performance, economic restructuring, or shutting down the business entirely. But over on the right, unlawful dismissal rears its head when there's no just cause, or, and this is a big one, when the employer totally fumbles the proper legal procedures.
Because here's the kicker. Just having a valid reason isn't enough. The process matters just as much. Employers have got to follow these specific steps. First up, written notice. You have to clearly outline the exact reasons for the dismissal. Second, if you're letting people go because of restructuring or redundancy, you can't just go rogue. You need prior approval from the Commissioner of Labor, and yes, you need the financial receipts to back up your claim. And third, if it's a misconduct firing, you are legally bound to hold a fair disciplinary hearing. Honestly, skipping these steps is a surefire way to instantly turn a totally justified firing into an unlawful termination.
Moving on to Section 2, Navigating the Labor Tribunal.
39. That's a number you should probably remember. There are exactly 39 labor tribunals spread across Sri Lanka, and their sole job is hearing and resolving termination disputes under Section 31B of the Industrial Disputes Act. Think of them as the primary battlegrounds where private sector employees, domestic servants, and semi-government workers go to fight for relief. And here is the magic number for workers: 6. Under the Act, every single application to a labor tribunal has to be made within a strict 6 months from the date of termination. Not 6 months in a day, 6 months. If an employee waits 7 months, well, they're entirely locked out of this legal avenue. When it comes to the tribunal, timeliness is literally everything.
So what happens if a worker files within that window and the tribunal agrees the dismissal was unlawful? The tribunal basically unlocks an arsenal of powerful remedies. They can force the employer to reinstate the worker, maybe even with back wages. Or, let's be real, if the relationship is completely beyond repair, they can order a hefty financial compensation package instead of reinstatement, plus settling any outstanding gratuity and pension benefits.
Let's look at how this plays out in reality in Section 3, a landmark tribunal case. Take a look at this. It's an original court document from a wild and honestly tragic scenario back in 1986. ACC&I Workmen's Union versus Colette's Ltd. The worker in the middle of this, SM Randenia, actually passed away in 1983 while his termination appeal was still pending. Talk about throwing a legal proceeding into completely uncharted waters. This wild curveball sparked an intense legal showdown. See, the application was originally filed by a trade union on behalf of Mr. Randenia. The employer jumped on this, arguing, hey, union membership ceases upon death, so the union can no longer legally represent a deceased man. Throw the appeal out. But on the other side, Randenia's widow stepped up, fighting tooth and nail to keep the appeal alive to get what was rightfully owed to her family.
And the judge's ruling on this? It became a total cornerstone of Sri Lankan employment law. The court laid it out perfectly. Sure, obviously you can't reinstate a deceased person to their job, but, and it's a massive but, their heirs have every right to pursue the financial claims for services already rendered. So, the union was allowed to keep prosecuting the appeal, ensuring the widow could recover the compensation, the gratuity, and the back wages her husband had earned before that unlawful termination.
Which brings us perfectly to Section 4, how compensation is awarded.
How much will the tribunal award? It depends. I love this quote because it hits the nail right on the head. You might be hunting for some neat, strict mathematical formula, but guess what? The Industrial Disputes Act doesn't give you one. No set cap. no set minimum. Instead, the law hands the tribunal incredibly broad discretion to make an order that is simply just and equitable. Kind of terrifying if you're an employer, right?
But, okay, while there's no strict math, tribunals aren't just pulling numbers out of thin air. They consistently weigh a few key factors. They're looking at the length of service and the last drawn salary. They look at the employee's age. Because older workers with fewer job prospects, they often get significantly more. And crucially, they scrutinize the circumstances of the dismissal. If you, as an employer, vindictively march someone out the door without a fair domestic inquiry, prepare for a massive financial hit. Actually, let me emphasize that. A well-documented, fair inquiry is literally your best shield against an astronomical payout.
Finally, let's talk about the money waiting at the end. Section 5. Understanding gratuity payments. This breakdown shows exactly who gets a piece of the pie under the Payment of Gratuity Act. If your workplace has had 15 or more workmen in the past 12 months and a worker hits that 5-year service mark, they are eligible. Boom. The employer owes them half a month's wage for every completed year of service, and you've got exactly 30 days from termination to pay up. Do keep in mind, though, the law does carve out exceptions. Domestic servants and workers on non-contributory pensions are specifically excluded here.
Now, for the employees out there, keep in mind this gratuity isn't just an unconditional guarantee. An employer can forfeit it, but, and it's a big but, only to cover actual financial damages caused by the employee. We're talking extreme stuff: fraud, misappropriating company funds, willfully trashing property, or causing a massive loss of goods. You can't just dock someone's gratuity because they were consistently late.
And for the employers tuning in, you absolutely cannot afford to drag your feet on this. Miss that 30-day payment window, and you trigger a brutal, escalating surcharge scale. Look at this. A month late? That's a 10% penalty. If you delay over a year, you get slammed with a massive 30% penalty on top of the original gratuity. And if you keep ignoring it, you could find yourself standing in front of a magistrate who can treat the default as a fine and, yes, even impose prison time. No joke.
So as we wrap up this explainer, I want you to really think about this. Does your own workplace actually measure up to the strict legal frameworks we just unpacked? Remember, a single missed deadline or one messy, undocumented hearing is the razor-thin line between a clean break and a crippling legal penalty. How exposed are you right now? Thanks for joining me.